energy system can support it. So we'll have competition there. There will be other consequences. As we understand the antitrust, the question of whether competition is good or bad is resolved. It is only about competition without any exception, or if there is exception, there should be statutory. Okay, so this is kind of, I just want to emphasize, it's not that we diminish any of the points that people made, it's rather we think that not all of them are within antitrust. And just to illustrate another point in terms of 2 points, A, the Google case, and B, the Twitter lawsuit against advertisers. So the Google case, I agree with Doug that the Google case actually was extremely within the traditional framework. The issue with Google was that the creation of barriers to entry is harm to competition. We saw that in Microsoft as well. This is extremely well-established standards. In fact, the classic case is from 1951, Lawrence Journal. I'm unaware of any person who said this is a bad case, the Lawrence Journal. So the Google case in that sense was traditional. The other thing with respect to ESG, last week, the lawsuit, there was a...
within half an hour, dude. Okay, so I should just...
Last week, X, formerly known as Twitter, filed the complaints against a trade association of advertisers, saying that they colluded against the company to boycott advertisers. When the news alert came on my phone, I thought, oh, this is a crazy conspiracy theory. When I read the complaint, what became clear to me is that the evidence is quite overwhelming. They had good intentions to protect democracy, to protect society from many evils of social media. But the reality is that based on the evidence presented in a complaint, only in the complaint, it seems that they crossed the line between and agreed not to compete. So again, there are many bad things. We should focus on competition. Thank you.
This is going to be kind of me too, in a way. I was particularly focused on the ESG discussion initially, where on the one hand, we're told, hey, it's going to be pro-competitive, which means that any rational business will engage in this activity as a profit-maximizing activity. On the other hand, maybe it's a good thing because we are going to increase our costs, et cetera. But if we're going to do that, again, this is like the advertising collusion. How exactly is this going to work? Who's going to be making the decisions? How much are costs going to go up? I think that having somebody take a more extended look at this, we have an EPA that can mandate certain kinds of things. The industry can petition the EPA to impose those rules that it now believes are necessary, and they can go through an appropriate public interest kind of review. Again, I think that you may want to have a better report about how some of these good thing excuses for collusion. I've sometimes told my students, no one ever colludes, but they're thinking about the needs of the country and of their shareholders and the widows and orphans who are dependent on them. So it's worth looking at. I will also make one passing observation on the concentration story. As markets get concentrated and you have fewer and fewer competitors, the incentives to engage in either tacit or express collusion increase. We've talked about AI's role in that area. I think saying, oh, ignore collusion is a very wrong-headed way of thinking about things. There are exceptions. There are cases that need to be looked at. But if a market has few competitors, you ought to look more critically at what's going on. Thank you again.
Thank you. We have a few minutes for panelists to make any final comments. I see Mr. Heppner has his hand up. So Mr. Heppner, the floor is yours.
Thank you, commissioners. Just a couple quick responses. It wasn't my intent to characterize the Google decision as transformative or so outside of the box. I do think, and I think that Professors Melamed and Orbach agree that it is a decision about protecting competition. I think what is novel in that case is that the traditional measurements of competition, like increased output, and increased innovation, if it's being conducted by the dominant firm, are not necessarily an excuse to behavior and conduct that harms competition. And so I think what I'm trying to articulate there in response to the Consumer Welfare Standard report is that the Consumer Welfare Standard was introduced and brought into jurisprudence in the 1970s as a constraint on the enforcement of the law. And whether that's true as a matter of law, it is absolutely true as a matter of enforcement priority. And I think that all of the panelists, from Professor Melamed to Professor Orbach, agree that restoring the principle of antitrust law to enforce against harms to competition for competition's sake is a healthy direction for this body to move in. Abuse of dominance, I think, is one way of saying that. I think that we disagreed and we articulated our disagreement with the Single Firm Conduct Working Group's report on that. They said that abuse of dominance is weak or is vague, impermissibly vague. The Consumer Welfare Standard report offered by Professors Orbach and Melamed offer different phrases that are similarly vague, that suffer from the similar vagueness. So in my presentation, I tried to present that we should also articulate what we mean by that, and that articulating per se violations of the law is a helpful articulation of what we mean by abuse of dominance or harm to trading partners. So I do think that this is all consistent with the recommendation that a single firm conduct standard can reiterate a broader conception of the law that is about protecting competition, not cabined or limited or constrained by the Consumer Welfare Standard, and that we can explain what that alternative standard looks like in the law itself by articulating some of the conduct that courts have repudiated, whether that's substantial foreclosure in the Google case or elsewhere.
Thank you. Commissioners, any questions or comments for the various? We'll come back to you, but I realized I have not engaged my colleagues yet in the past hour and a half. Commissioner?
Yeah, I have a question for the WISPA folks.
Sure.
Maybe it's just me. I'm not sure I understand what a sustainability collaboration is, and why, and to what is it a threat?
There are certain lawmakers and enforcers. Thank you. There's certain lawmakers and enforcers that, in our view, are politicizing the idea. They're basically relying on the antitrust laws and twisting them to say, because they're basically anti-ESG focused. So you can't have sustainability in the environment by one actor. Necessarily, you need collaboration in the industry in order to reach sustainability, and whether it be petroleum or another energy type of energy. So I think that it's important to realize that what's been created is an atmosphere in this nation of uncertainty of what is and is not permitted, which is why this is an unusual area, very much like AI, and why you've asked for a further report on it. ESG is in the same sort of category where it is unusual, it is new, and it's being, unlike perhaps AI, but it is being politicized. Therefore, to parse through it and have some objectivity, we believe strongly that there needs to be further study into the areas that we focused on, whether there be formal guidelines, whether it be ad hoc guidance, whether it be actual safe harbors, whatever it be, we need a whole new set of expert reports to study those issues and see if they're appropriate in this unusual environment.
I guess
I would just add the specific collaborations that have been attacked most aggressively have been well, I mentioned these net zero alliances, and
what's that?
So one of the main examples would be asset managers as a group across the industry have said, we don't want to invest in companies that don't have, meet certain sustainability thresholds. We only want to invest in companies that are, pledging to reduce their carbon footprint, that are trying to meet the Paris Agreement, that kind of motivation. And the attack has been by different asset managers. So, BlackRock, JP Morgan, they can't come together and say, we only want to invest in companies that meet these sustainability goals. That is
how is that different from an asset manager who says, I only want to invest in a food company that doesn't have saturated fats and and, some other non-healthy.
I think the debate is whether, whether that is a valid consideration of, value that is, meaningfully economically to asset managers, or whether it sort of, breaks the mold in some way that makes it prohibited, and it's promoting something that's different than economic welfare. And I would
Wouldn't that be up to that would be the kind of a investment policy that might appeal to some investors and not to others. They might, I guess I try to.
Rick, I think the disconnect might be, I don't think Mr. Brand is saying an individual can't do that. I'm hearing him say they all want to get together and make a decision together to essentially not invest in certain companies. Is that correct?
The collaboration that's being challenged.
And has that been attacked on an antitrust basis?
Yes.
Okay, I think that's the core point.
Okay.
Any follow?
No.
Well, we've got them. Okay, any other commissioners? Commissioner Correa.
Yeah, directing my question to the experts on Zoom. I think it was Mr. Hefner, one of his slides made the statement that a takeaway from the Google search case is that the consumer welfare standard is dead or all but dead. Mr. Hefner, did I read that right? Was that you?
Yeah, but that was actually a quote that wasn't about that. That was a quote from an article by another scholar, Steve Salop, from an article unrelated to the Google trial. And he said that the consumer welfare standards days are limited. And I think
Right.
what he meant by that is as a limitation on antitrust enforcement.
Right, but so is it your point that actually is it turned out to be one of the takeaways of the Google search ruling, that the court abandoned the consumer welfare standard?
I think that if you read that decision carefully, what the court did is issued a very narrow, found a violation that is about harm to competition, and avoided finding a violation that was predicated on whether consumers were actually harmed. Because in fact, what you saw, which are indicators of consumer benefit, are increased output and increased innovation by the dominant firm, but that was not dispositive of a violation of the antitrust law, which was about harm to competition. So in effect, I do think so, yes.
Okay, so then my question turns to Professors Mehlman and Orbach, who I see both have hands up. What's your take on that? Do you think that's a fair takeaway from the Google search case?
I think it is not. And the reason I think is not is that if you cannot find literally a single judicial opinion where a court said, this is the consumer welfare standard, or this is what it means. Actually, courts rarely, if ever, refers to it. What they sometimes do is they say that harm to competition also should have some kind of application for consumer. And when they say that, what they have in mind is that the practice that they challenge will raise prices, or that they cannot see the effect. So I don't see that. I think that, there is a consensus, unanimous consensus, that the label consumer welfare was poorly conceived, misleading. I do not think, and I've studied, I spent way too many years studying that. I do not think that the way it is described in the literature is anywhere close to the practice of how courts do that. So what should die is the literature that makes no sense. It will be enormously important to develop what is harm to competition. And I think at the end, we should clearly not all of us, many of us, or I think most antitrust experts believe that it should have economic effects, not any specific economic effects related to market transactions, as opposed to any economic problem or other social problems.
If I may, I just add a brief thought. I agree entirely with what Professor Orbach said, but the reason I have emphasized in my comments market power, which is a consequence of weakening the discipline of rivals, is that market power to an economist and to an antitrust lawyer, by definition, is the ability profitably to take action contrary to the interests of trading partners. You could lower the wages, you could increase your price, you could reduce the quality of your product, reduce investment in innovation, whatever it might be. But it's market power that's the key. The bad consequences for trading partners follow as a matter of prediction from market power. They don't have to be proven in the individual case, like the Microsoft case or the Google case. I agree with Mr. Heppner about that. But saying they don't have to be proven in the individual case in no way undermines this conceptual framework of weakening the discipline of rivals, gaining market power, and not being able to justify that as necessary to bring forth some benefit for trading partners.
And I might just say that that might be an articulation of an abuse of dominance standard, Professor Melamed. But we can take that conversation offline.
Just jump in. Yeah, I was going to actually ask the same thing. I'm trying to distinguish between symptoms and problems. That dominance, concentration in a market could be as a result of anti-competitive behavior. And it sounds like what the Google case found was that was what happened, maybe. On the other hand, someone could become dominant in the market because they have better product or services, they're more efficient, that sort of thing. And it's feeling like just being big isn't necessarily a problem. It's, do you undertake anti-competitive type of behavior because of that, to stay big, to get bigger, to keep competition out? And so is an abuse of dominance, abuse of that market power, what really ought to be the focus of the antitrust law, as opposed to being big all by itself? And I'm struggling with how to think through that.
If I may, I think that I may be able to help. Competition, the goal of antitrust is actually when we say the goal is to protect competition, not to have competition among commodities. Competition, really fierce competition, is the punishment in the marketplace for not being innovative. So companies, for-profit companies, they always try to escape something that is close to textbook market competitive equilibrium. What antitrust does is evaluating whether these escapes are legitimate or illegitimate. For example, if you're innovative, good for you. If you're creating barrier to entry, such as what Google and Microsoft have done, that's illegitimate. So it is a difficult exercise, but the point is that just bigness is not enough. Now, the problem with the phrase abuse of dominant position is that it is taken from different jurisdictions where they have specific meanings which are inconsistent with the US law. For example, in most jurisdictions where abuse of dominant power is indeed an antitrust claim, high prices are antitrust violation, are abuse of dominant position. So of course we can take any label and define it anywhere we want, but we already have a problem with poorly defined label, which is consumer welfare. I think we should be really cautious before we adopt another label because it is used in other countries, not knowing that it's not necessarily consistent with antitrust, the US antitrust laws.
If I may.
Thank you. Now, Mr. Manny was waiting, and then I'm going to ask Ms. Comsty if she has further comments. Mr. Manny?
Thank you. I think the important thing to remember is as Mr. Simpson said, there are multiple causes for what we may observe, for indicia that we associate with the lack of competition, but it's not always necessarily the lack of competition. One of the problems with an abuse of dominance standard is related to that. It's that we operate under an assumption that, for example, the ability to charge higher prices is associated with an absence of competition. That's just not true. We may prefer to pay lower prices, but in a lot of contexts, if it's a legitimately earned monopoly, charging somewhat higher prices is the thing that incentivizes companies to innovate to become those monopolies in the first place. And we don't want to get rid of that. That would be catastrophic, especially for California's economy, which is very much dependent on companies that have the incentive to try to innovate and become very large. So I think the key thing is this notion that you really do have to have an effects-based approach. You really do need to try, it's difficult, but you really do want to try to find a way to assess what the competitive effects are of the conduct that you're investigating or challenging. And if you take too many shortcuts and look at indicia that you think are consistent with a decrease in competition, you're going to get it wrong, and getting it wrong actually has costs. Over enforcement is actually costly, and you want to be very careful to optimize enforcement, not to maximize enforcement.
Ms. Comsty?
You know, with the conversation that we've been having this afternoon, I think, you know, one of the things that keeps on popping into my mind is that we're looking at under current mostly federal antitrust law, we have the rule of reason that looks at, is bigness too bad because or is bigness okay because there is some sort of reasonable competitive conduct. I think what you know, what we really want to look at with CNA and a lot of consumer and labor advocates wants to see the opposite. What are the harms? Is there a harm from bigness that we need to control under antitrust law? And I think, you know, with what Professor Melamed said about, you know, economic welfare, what we're looking at with labor harms, harms to patients, I think those are fundamentally economic welfare issues, because if you do not have the suppliers, the producers that make a product or a service like healthcare workers or other types of workers, or if you do not have patients that consume those products, that need to use those products, where's the market? It does hurt competition in the fact that it, particularly when you're looking at hospital closures, it's a dominant firm deciding that they want to shut down the market and make a lot of money while they're leaving a market. And I think, you know, we haven't talked about this today, but the role of private equity and the financialization, particularly in healthcare, really highlights this, where you have PE coming in and selling very critical needed services in a hospital or a healthcare system for parts. And we find communities all across California, you know, Madera Hospital, Hazel Hawkins Hospital, they've been going through these problems of, can they stay afloat without having some sort of, you know, some big private equity firm, some big healthcare system buy them up only to keep the most profitable parts. And I think those are really, it's a really important question to figure out, what are the standards that we can clearly articulate in California law to address these issues. And this is why, you know, I think Lee mentioned this and a number of other presenters and experts on the working group panels earlier. Are there per se violations that can be articulated in California law? We don't have the complete baggage of the consumer welfare standard, and you know, whether or not the terminology has been interpreted into the Cartwright Act, that's a fair question because of the mashing of federal and state antitrust law interpretation, as we talked about earlier. But I think this is a good place for the commission and the state of California to really look and see what are the standards that can be used and clearly written in our statute to say this conduct is hurting consumers, it's hurting workers, it's hurting trading partners, it's hurting government participants in a market. I think those are really important questions, and I think, you know, it's a great conversation to have, to say, how can we articulate those harms, whether it's abuse of dominance or some sort of other theory of injury that can be written in the law to ensure that we can promote competition while also protecting the economy as a whole and the people who are participate in it.
Ms. Comsty, are you aware of any jurisdiction in which healthcare was treated differently under antitrust regulation, because healthcare, unlike novelty shops or lawn and garden shops, constitutes a human security market? Or have you seen healthcare treated exactly the same as lawn and garden and novelty stores?
I think where healthcare has been a little bit different in antitrust law is that there are more, there's more investigation into competition and the particularly, California is a great example. We have our Attorney General hospital purchase transaction review for nonprofit hospitals. And that creates a structure for the Attorney General to go and investigate certain types of hospital closures, purchases, potential sales of hospitals. And there are, the AG can engage and hold public hearings and engage with stakeholders within a community to figure out what the harms can be. And then the Attorney General can put conditions on the sale. So, it's not necessarily a different standard, but this is a little bit more in terms of what enforcers can do with potential anti-competition within a merger context.
So you've seen heightened scrutiny,
Yes.
but not different standards articulated.
Correct. And I think, I mentioned the Office of Healthcare Affordability. It's looking at cost and market impact review. It's somewhat similar, but broader than what the Attorney General has in terms of their review scope. However, the Office of Healthcare Affordability does not have enforcement authority. They will investigate and then refer their investigative matters to the Attorney General. That this just only a few months ago got off the ground, so we'll see how that works. But in theory, those standards that they're using there, including a workforce stability standard, could be overlaid onto antitrust law in general. And I think, I think it's a very interesting space because there's a really deep look in terms of what are the important factors specific to healthcare, but also generally. And I think, there's a lot of thought process in terms of, there's something is missing in looking at market failures within the healthcare system. And, California is trying to figure out what to do with that. And, for us, for CNA, I would wager other consumers and workers would want that additional type of investigation into market failures that impact workers and consumers.
Thank you. A couple of things. Any commissioners with any further comments or questions? No. I see that we've got with us again, Mr. Robbins. Before we run out of time, why don't you come to the microphone and give us your couple of minute report on the ULC Pre-Merger Notification Act. I'm sorry? Keep our panelists here for now. I just don't want to run out of time and leave Mr. Robbins hanging. Go ahead.
Is that okay? Good, thanks. Yeah, I'm Dan Robbins. I'm the chairman of the Uniform Law Commission Antitrust Pre-Merger Notification Act, and also a member of the California Commission on Uniform State Laws. As Kathleen Foote mentioned earlier, we have a serious issue today in merger review. What happens is the federal government gets the materials under the Hart-Scott-Rodino Act for any deal that's over $120 million. The states don't get that material. The states, under the Clayton Act, can enforce federal anti-merger law. But what happens is the feds start their investigation. There's two agencies. They'll go months and months down the road. Then the states may learn about it. So they're always playing catch up, and it's hard for them to coordinate. So what this bill does is it requires companies that are doing these transactions to also share that information with the state where they have their principal place of business. And any state who enacts the act can also share that information. So what the goal is here, excuse me, is to get the information to the states sooner, and allow them to share it with each other and to share their work product, their economic reports. I think someone mentioned earlier, economists are very expensive. So it'd be nice for the states all just to hire one and not hire 50. The act also allows the sharing of that information with the federal government. So basically what we're trying to do is get this all done at once, share all the resources so we don't waste time, energy, and taxpayer dollars, and get to the right decision. The California AG has been involved, the New York AG, but I also wanted to point out that we've had lots of businesses involved. And from the business perspective, what they get is the material stays confidential and they get certainty. You know, the deal is done. When I was a very young man, I think I worked nights at the AG's office when Kathleen started. And we had a case where we wanted to challenge a merger, but the feds had already approved it. So we were way, way behind the curve, and we took it. That was lucky in alpha beta for those who have been here a while. We took it to the Supreme Court and won. I was just a kid in law school doing research, so I don't take any credit for that whatsoever. But that's how it's not supposed to work. You don't want all that duplication. So the update I wanted to give you is we've had 3 developments. One is on July 12th, the American Bar Association officially endorsed the act. The section of antitrust law endorsed the act. On July 19th, my commission, the California Commission on Uniform State Law, approved it unanimously. And then it went to, so all the commissions get together every summer and debate all the different bills. And so this bill was put forward for debate, discussion, and vote at the annual meeting, and it passed 45-1. So 45 states, including California, voted in favor. The only state that voted no was Alabama. I'm not really sure why, but that's not a priority at the moment. I'll go back and figure that out, but it was an overwhelming endorsement. What happens now is the bill goes to our legislative style committee that's chaired by someone you may know, Diane Boyer-Vine, who's our former legislative counsel. She'll do the polishing on that. Then it goes out for enactment. So I plan to seek an author in California. I'm hopeful it's all consistent with what you all are doing, and then try to get it enacted in about 20 other states too. So that's my brief report. And one other thing I'd like to mention is I think Commissioner King said something I thought was very important. Like if you want to get something passable, you need balance. And this was my goal in this particular bill. You know, we had business the whole way. I've had the U.S. Chamber of Commerce. Everybody is fine with it. I've had the AGs the whole way. So I think that's sort of the key when you go through and consider your recommendations. You know, think about what happens in the business community, what happens with the AGs, and to try to find something everybody can, you know, somewhat agree to. I know that can be difficult, but that's, I wanted to give you that update and feedback.
Thank you very much. Now, Ms. Johnson, have we done what you were hoping we would do today, or did we miss something?
No, I think we've gone through this set agenda. I think we still have public comments left.
Yes, but before we get to that, I wanted to make sure you were happy. Delirious. Very good. Do we have any members of the public who would like to be heard before we close this segment? Anyone with their hands up you can see? Excuse me?
Is there anyone here?
No, I don't think there's anyone here, but I mean online. Okay, why don't you let people in and as you see their hands go up.
Jamie, you're allowed to talk.
Hi there. Thank you. Good afternoon. My name is Jamie Huff. I am the Vice President and Counsel for the Civil Justice Association of California, CJAC for short. We're an organization dedicated to improving our civil justice liability system. I appreciate the opportunity to give public comment today, and in the interest of time, I will keep this brief. I know you've been at it for a while. We would just request that as the commission takes input on suggested changes to our antitrust law, that we would heavily weigh the potential impacts to our civil justice system. We're concerned that a number of the proposals being considered would increase unwarranted litigation burdens on business and thereby have a negative impact on consumers and the state's economy. We would recommend that the commission not make extensive sweeping reforms to existing law. We believe our current antitrust law already covers a robust enforcement. Duplicating federal efforts or adding additional regulations could be excessive and overall harmful to consumers. One example I would mention is an area being considered as a reform would pertain to concerted actions. We have concerns about reforms in this area because businesses and collaborations therein can have huge beneficial value to consumers, as we have seen in the drug manufacturing space, for instance. When all expertise and capabilities can be brought to bear, it really can provide pathways for essential innovations and life-saving therapies, and we wouldn't want to close the door on those. We know California already allows for a broad private right of action in this area, so broadening the scope of antitrust law without also looking at reforming the current remedies could exacerbate an already hostile legal environment in our state. We'd appreciate it if any reforms that you make to this law are done with the goal of promoting balance in our civil justice system and keeping that at the forefront of consideration. And lastly, we would just request that the commission provide a sufficient amount of time for public comment on any proposal it issues, given the complexity of the topics under consideration and potentially far-reaching implications across all business industries. So thank you for allowing me the time to speak, and I appreciate your consideration.
Thank you very much. Anyone else waiting?
Hello, can you hear me?
Yeah, Terry.
Hi there.
Hello.
Am I coming through in the room?
Yes, please proceed.
Fantastic, thank you. My name is Terry Oley. I'm the Director of Economic Security California, and really happy to be here today. Just appreciate again the just deep work that the commission and the working groups have been doing on so many topics. Just a couple of points I'll make. Also want to try to keep it brief. I know it's been a long day. First of all, I'm just really glad to hear about the AI panel proposal for October. This is a really important new area that I think has really exploded in the last year since you all began. And so I'm looking forward to hopefully being able to participate in that discussion. And it's an area where concentration is rampant, and I think will be bring a lot of these issues to kind of a concrete point. Second, I just wanted to lift up a little bit some of the areas where we heard a lot of agreement today. And I would say overall, the overarching thing I heard from the working group discussions today is that the status quo in California is not working, and that we actually here in California have the ability to fix it. And we have some of the best minds putting their energy into coming up with what that looks like. Specifically, some recommendations based on that. One, the single firm conduct in California, with the lack of a single firm conduct standard in California is really hampering the ability to address anti-competitive conduct here, and would really want to reinforce the recommendation to instituting a single firm conduct standard here. I also want to kind of re-up the discussion that happened earlier about per se conduct and the need to recommend clarifying the law to expressly prohibit conduct that has actually already been deemed unlawful by the courts. I think that's a really important piece of our antitrust architecture here in the state. Second, around the consumer welfare standard, at least to my ears, there's a lot of agreement from the working group reports and previous information that that standard is really insufficient to evaluate whether there is robust competition in a market, and that articulation of a broader or different standard would actually be really helpful and go a long way, provided, of course, that we avoid vagueness in that standard. And of course, reasonable minds can disagree about what words we actually use to define those standards, but it's really important that we restore the ability to enforce against harms to competition, and to think about what that means is something much more broad than just price or the consumer effect on consumers. Finally, thinking a little bit about that consumers benefit, there are consumer benefits that are more than just price. So market entry, new entrants, new businesses, and innovation are also part of what impacts consumers. Third, enforcement. Heard a lot of agreement in the discussion of that earlier today that we need more clarity in the law. And then in addition to that, it seemed like there were two areas that were very important. Number one, in public enforcement, we need expanded, would recommend and urge you to consider expanding the AG's authority in California to be able to protect against anti-competitive conduct. But then the other thing that really landed for me was the need to examine what's happening on the private side of enforcement. 90% of cases, antitrust cases are brought on the private side, not by public enforcement. And we need to make sure that the tools exist there. And we have to look at things like class action waivers or antitrust arbitration clauses and other things that are actually barriers to getting your day in court. And then finally, wanted to just kind of remark big picture on the political question that kicked off the day. And that is really thinking about like what the role of the CLRC is with respect to making recommendations. I think that there's been a lot of conversation about like what's going to fly when you get to the when we get to the point of the legislature and perhaps a legislative proposal, and that there are political considerations to be made. While that's true, I would simply suggest that the right and appropriate use of this body's time is to actually put together legal and policy recommendations that will address the problems that have been so clearly laid out over the last year and certainly over the last discussion of these last 7 working group reports. There is no perfect legislative proposal, and no matter what happens, there will be opponents. The business interests that are committed to the status quo will bring out all the firepower they have to stop anything from happening. But that is not really, that's really neither here nor there at this point in the process. I think it's important to note that there is a broad coalition in support of change. And I also will note that as this hearing was happening, I was also simultaneously paying attention to the appropriations hearings in both the Assembly and the Senate in the legislature today. And I think based on that, we can all agree that miracles happen in the legislature every single day. So I think that for now, thinking about the appropriate policy proposals is the right role for the CLRC. And I thank you so much for the service that you're providing in doing that. Thank you.
Thank you very much. We are approaching the end of our day.
We have one more.
Yes, but
Oh, okay.
Is there anyone in the audience in person who would like to offer a comment? Hearing nothing in the room, we'll do the last person on Zoom and then
Devin?
recap where we are.
You're allowed to talk.
Hi, everyone. Appreciate you giving me a few minutes to speak. I'll be brief. I know it's been a long day. I'm Devin Gray. I serve as president of an organization called End Poverty in California, or EPIC for short. Just want to urge the commission to seize the opportunity to update the anti-trust framework. Obviously, many subject matter experts have given their opinions on the merits of this, but I think it's useful if I offer a perspective from the point of view of everyday Californians, including the nearly 5 million living in poverty today. As an organization, we spent the last 2 years traveling across the state to listen and learn from Californians about the concerns of the state's economy. We spent time in over 20 counties now, and while our state is incredibly, there are certainly region-specific challenges. Some consistent themes across the state that people are experiencing wages that aren't keeping up with the cost of living. There's a lack of assets upon which to build wealth, and there's barriers to entry for would-be entrepreneurs and small business owners. And I think there's a keen understanding among folks that we talk to that corporate consolidation and its related anti-competitive effects are actively contributing to these conditions. I'd like to hone in, however, on how anti-competitive practices hurt workers in particular, because so much of our antitrust regime, of course, is focused on the effects of consumers, the impacts of market consolidation for workers, particularly low income. It's far too often overlooked, I think. Like I've said, we've spent time in every corner of the state, but I think the lessons that we learned in the Inland Empire are maybe the most relevant to this phenomenon. As many know, the Inland Empire is home to a huge amount of warehouses and distribution hubs. It's a region that is central to the supply chain for the entire country, mainly because of its strategic location along major highway routes and in Southern California. And as such, companies like Amazon have had a huge presence in these majority non-white communities, which themselves have been underrepresented and have extremely high poverty rates. Now, this region is always going to be a hub for companies like Amazon. There's nothing inherently wrong with that, of course. But it makes a lot of sense why they'd be there. But the problem for workers emerges when Amazon becomes so dominant in the local economy that other market actors simply can't offer competitive wages or working conditions. And predictably, Amazon has been able to keep its wages quite low, maintain troubling working conditions, intimidate workers who try to organize, and damage the environment in the communities where it has warehouses. But under the current antitrust regime, which centers the consumer welfare standard, which we've discussed at length here, Amazon isn't running afoul of the rules because the low prices that they offer don't hurt consumers all that much. But they're able to do because they prioritize growth over their own profits in order to maximize their market share. So it's clear that the shifts that happened, in the last 4 or 5 decades, namely, this introduction of the consumer welfare standard, leave serious blind spots in our ability to enforce antitrust policy. And these are blind spots that are particularly harmful with these types of firms where the downstream effects, particularly for those who are poor and people of color, aren't fully captured by such a narrow definition of consumer welfare. So call to action for folks is to reevaluate the standard. Maybe we can center it around public interest. Maybe we can center it around the labor market, taking into account how these business practices impact wages, job conditions, and job opportunities. So want to just close by saying, the economy that we want to build is within our control. We have a state of immense abundance, and we can shape the economy that we want to make sure that every Californian can achieve all of their hopes and aspirations. So thank you all. I know it's been a long day as well.
Thank you very much. I understand there's one more person on Zoom. Let's take that comment and then we will adjourn. So if you can close the room then, great.
Donnie, you're allowed to talk.
Thank you. Good afternoon, everyone. Thank you again to I'm here representing Rise Economy, a member-led alliance of around 300 nonprofit organizations throughout the state dedicated to creating systemic change, economic justice for BIPOC and low-income communities. We focus on advocating and combating the legacy of redlining in these communities and holding banks accountable for their role in creating community-centered economies. One core aspect of our work is to mitigate the harms of bank consolidation brought on by sort of ceaseless mergers and acquisitions, and to ensure that where there are mergers, there's a clearly articulated public benefit. This is an area we'd like to see the Commission confront more critically within the context of antitrust, anti-monopoly discussions. Bank mergers can do irreparable harm to communities, and the current bank merger process, both at the federal and state level, are strongly biased in favor of approval and lack sufficient safeguards to protect consumers and communities from the excesses of corporate power and consolidation. The vast majority of mergers are approved, even when significant concerns from community groups and members about the negative impacts they'll have are shared. We've seen as a result of this, communities suffer in the form of lost jobs and reduced hours and working conditions for community development and frontline bank branch staff, closed branches, decrease in reinvestment activity, reduced access to credit for small businesses, higher costs and fees for bank consumers, for customers, exacerbation of climate change concerns, and greater climate-related financial risks to the financial system. Also, mergers that are not adequately scrutinized pose a significant risk to the broader financial system in California. Some examples in recent years include the Silicon Valley Bank and First Republic Bank failures. These strongly suggest that greater regulatory oversight is necessary. And I'd like to echo an earlier point that was made that I think a lot of us and certainly the report authors would also appear to agree that the status quo is not working for California, and that California has the ability to really fix it. A modern, responsive, and robust antitrust, anti-monopoly enforcement framework is what's foundational for empowered and informed consumers, valued and respected workers, thriving small businesses, and healthy democratic institutions. I'd like to also point that the consumer welfare standard is not sufficient to holistically assess and address the harms of modern corporate concentration. A better approach would be to establish rebuttable presumptions of anti-competitive conduct and consider a new standard that explicitly takes into account broader concerns than short-term price impacts. So thank you again, folks, for your time, and really would urge the commission to look at the impact that bank mergers that are vastly underregulated have on our communities.
Thank you. Thank you again to all of our panelists and to everyone else who offered comment. We appreciate your insights, and we appreciate the help you're giving us in fighting our way through this very complex project. Are there any final comments or questions from commissioners on this agenda item? Hearing none, we've come to the end of our formal agenda. Is there a motion to adjourn?
So moved.
Is there a second? Is there any opposition? Hearing none, the hearing is adjourned. Thank you all.